this area. Hey, when you booked the room for the sharing thing, what did you use?
What do you mean?
Did you use like third party Expedia type of thing or just directly?
I just did it.
Okay.
Hey, who's up there on the video?
Claire.
Where are you?
I just got home from Santa Ana
Oh, okay. And where's home?
in San Bernardino.
That's a long way away.
I know, it took me 2 hours.
Yeah, Santa Ana to San Bernardino is a long way.
Yeah.
This time of day. All right. What?
Yeah.
Asking a question out of class.
Is,
Are you doing the, education for, legal writing?
Yeah.
Don't we do basketball and the other one?
we do?
I don't know, do we?
I thought it was one.
I don't know.
It was for blow, please.
Yeah.
She gave us the
Yeah.
the model where the memo was supposed to write. She sent that one. Did you get that one?
She just said it.
Yeah.
Okay.
Yeah. And then
I,
by today,
I'm text person. Sorry.
oh wow, that's cool, you know. Okay. It's one, it says do your research using these sources. I didn't read it really. Your phone? In your car?
I'm sorry, what did you say?
Your car?
Yeah.
There you go.
What did you say?
It's one assignment, I believe. It says use these cases.
Yeah, that's like the criminal ones.
Yeah, criminal law,
Yeah, like
World's Universe. I think
the
that's
schools
it.
universe.
Yeah.
That's what I want. Okay. Oh, did you get a basketball one too?
Basketball?
Yeah, I thought about basketball. They came in.
Oh my gosh, don't scare me.
No?
Don't scare me.
Well, yes.
Wait, thinking about that.
Okay. October 11th. All right. So where'd everybody go?
I didn't get a text or anything, so.
No, they're both here.
Oh, she went to her car and Daniel?
Okay, so this week we're going to talk about stuff. Great. Somebody have a copy of the stuff that Nolan sent to us? I printed it out and left it on my desk. That's just great. Thanks. I'll be back. And don't forget to sign the sign sheet. Veronica showed it to us.
Probably 80s, 85s. I was like, nope, I'm not.
Sorry.
Can you tell if this is yours? Yeah, well, yeah. Even the first one is the contracts are like both 85s.
The crimes.
I didn't get full access, I didn't get to the crime.
Those just are really
It's
nice.
not gonna be sick, yeah, I got a 70.
Those- That might be high for.
So one contract says a 75, that's like, I'm gonna get 75. It was this.
I'm Jack, I know those were good too. Are you mind for that?
Good.
I didn't have a chance to see on that.
What is it?
Everything is getting
It's a
good.
regular charge and then it's the whole, like the blueprint for the SME.
All right, back at it. So, this week we're gonna look at stuff that looks like evidence that you would admit to show, of course he did it, because he had a propensity to do it, because he did other bad stuff. But it's actually being used for some other reason. So of course, what's always an objection to this stuff?
403.
Absolutely. Yeah, it's going to confuse the issues because you're telling the jury consider it for this, but not for that. And often it's got substantial prejudicial value because, you know, he did it once, he can do it again. Right? And the strength of that objection may vary depending on why you're introducing it. Okay? So, we've got, by the way, Professor Nolan has got some hearing today somewhere. And he emailed me earlier that the hearing was going on, and he's not going to be here. So, he may be here, but he may not. I'm not counting on him. All right. So, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with that character. Man, does that sound familiar, right? Where have we heard that before? Okay. But evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, lack of accident. Notice, such as. So this list is not exclusive, right? You could come up with another reason that's not on this list. As long as it wasn't, he did it before, so he did it again. In a criminal case, so notice that this means it could be both civil or criminal, but in a criminal case, a prosecutor must provide reasonable notice of the general nature of that evidence and must do so before trial or during trial if the court says that's okay. The book talks about, in theory, the admission is that the evidence isn't offered to show character, but to show something else, right? So it's not really character, it's not personality, it's to show a whole bunch of other like mental stuff, right? Notice most of this is all mental, right? Motive, opportunity, intent, preparation, okay? Not that you actually did anything, although preparation might be. So that's kind of the distinction that the book draws between, well, it's more mental than it is act. Right. I'm not sure that really helps, but that's the way they explain the distinction. The other point they make is general character talks about, you know, you're a good person or whatever. This stuff gets really specific, okay? And so the more general it is, probably the less admissible it is. They give us a couple of practice tips It's often advantageous to get prior bad acts in by the opposing party. Yeah, no kidding, you think? The jury will, you tell them not to use it for the wrong reason, but they go ahead and do it anyway. So, what's a tip? Try to get it in if you can for a good reason, so that the jury will use it for a bad reason. That seems to be the tip. The other thing is, it applies in both civil and criminal cases. So, unlike last week where we spent most of the time talking about exceptions that apply to criminal cases, this applies to both civil and criminal. Although from looking at the list, it sounds an awful lot like criminal, right? But it does apply to both, okay? And final thing, although we talk about prior bad acts or prior specific acts or whatever, it could be before or after the charged event, right? It can be before or after the incident that gives rise to the reason we're having a trial. So, for example, I had a particularly awful murder case where the defendant was charged with being aware that her partner was abusing and killing their children and not doing anything to stop them. And the trial that we had was the murder of child number 2. And the prosecution wanted to introduce evidence of the murder of child number 1 and abuse of child number 3, who was in pretty bad shape when the police showed up and took him away. The fact that the bad acts or the other evidence of uncharged events took place before or after didn't matter. All that mattered was, did it tend to show that she had knowledge that her partner was abusing their kids and killing them? And even if it happened afterwards, it would tend to corroborate, hey, she must have known what was going on in the murder of child number 2. All right, so let's talk about our outline, and then we'll go through some problems. Okay, this is written by Professor Nolan, right? Prosecutors love to prove the defendant has a prior criminal record because it gets rid of that pesky presumption of innocence. Empirical studies show jurors are willing to give an accused the benefit of the presumption of innocence only if it's crime number 1. If they find out you've done bad stuff before, then forget it. But, which is why we can't introduce evidence of other crimes to show, well, he must have done it this time. But we can introduce it for another purpose. So, admissibility of evidence of crimes other than the one that the defendant is on trial right now for. And note that uncharged offenses just means uncharged in this case. It doesn't mean that you weren't ever charged. In fact, under certain circumstances, you can use evidence of a crime that you were acquitted of. Really? Well, yeah, because the standard of proof for a conviction is what? Anybody? Beyond a reasonable doubt. The standard of proof of admission of evidence of an uncharged offense is preponderance of the evidence. Okay, so this jury could hear exactly the same evidence and be perfectly consistent in saying, we think it was proved more likely than not that this defendant did that other offense, even though another jury who heard exactly the same evidence said, we don't think it was proved beyond a reasonable doubt that the defendant did that. Okay, so just because you get acquitted doesn't mean that that particular offense can't ever be used against you. And you can imagine a scenario where it could be really helpful evidence because it explained why you did the new crime, revenge or something like that. All right, so prosecutors like to get it in. That's why we exclude it. So often they look for a legitimate reason to get it in. And because it comes up so often, we've got Rule 404D. The definition of other crimes is really broad. It's a crime, wrong, or other act. What does that mean? Pretty much anything, right? Doesn't even have to be a crime. Doesn't even have to be wrong. It just has to be an act. Arguably, an omission would count too. And it doesn't say those other acts need have ever resulted in arrest, prosecution, conviction, or even be criminal, right? So it's really broad. 404B does not specify what types of evidence. So it could be a copy of a court record, a witness who says, I saw him do it, even if it was never reported to the cop, or often somebody who's been a victim or the recipient of the threat. Rule 404B usually comes up in criminal states. Some states, but not all, apply to civil cases as well. And for our purposes, it applies to both, right? Rule 404B states the general rule that evidence of bad character, prior crimes, or subsequent crimes and acts isn't admissible to prove criminal tendencies. Great. Now that we have that out of the way, let's find why we can get it in, and the jury can interpret it that way. Motive, opportunity, intent, preparation plan, knowledge and identity, and absence of mistake. Lack of accident. Yes, absence of mistake and lack of accident sound an awful lot alike, but you could imagine sometimes maybe they're a little different. But again, that list is not exclusive. So if you can come up with another reason to offer it, okay. Now, of course, just because you can come up with a reason doesn't mean that it's going to be admitted. First, it's got to be relevant. Second, there's Rule 403. And of course, sometimes 403 is going to be a really powerful objection. Evidence the defendant committed crimes other than or in addition to the one he's on trial for is clearly prejudicial, right? Upsets the jury, confuses issues. And now the defendant's got to explain, I didn't do this and I didn't do that. It may have low probative value because it's remote from the elements of the current offense. On the other hand, just because it relates to another crime or type of crime doesn't mean that it has low probative value. It depends why you're offering it. Now, this says, as a general rule, crimes offered under 404B should be excluded unless one of the 9 propensity reasons is a genuinely disputed issue. True, but again, it's not just 9. It could be more, and it just depends how helpful that evidence is and how actually harmful it is. For example, in my murder case, the worst injuries, the most horrific, broken bones and everything, evidence was of the victim in our case, child number 2. The girl had apparently far worse injuries than either of the boys, one of whom was killed. So evidence that another baby had died, while really bad, isn't quite as unduly prejudicial when you've already heard that this kid died and this kid was horribly injured. Then you're going to hear another one that's like, yeah, okay. It doesn't upset you as very much because you can imagine the other way around, right? Suppose it was a trial for injuries to kid number 3. Kid number 3 isn't dead, hasn't suffered as bad of injuries. Well, we're going to bring in all this evidence from kid number 1 who was killed and kid number 2 who was killed in an even more horrible fashion. In the case about kid number 3, you can imagine that might have a much more prejudicial effect, right? Okay. As a general rule, judge cannot know whether one of these 9 issues is genuinely disputed until after the defense presents its case. So the evidence is usually not admitted to rebuttal, maybe. Often it's admitted in the people's case. But sometimes it's hard to tell how helpful it's going to be. Of the list of things that you can use it for, not guilty only puts identity and motive into issue, even though motive isn't an element of the crime. The others aren't necessarily disputed. So now let's talk about each one of them. Identity. Other crimes, usually similar crimes for the same offense, are admissible if identity is disputed, the other crimes were committed reasonably close in time, the state can show the defendant committed the other crimes, and all the crimes were committed in a really distinctive way, so we can say, if you did one, you did them all. This can be really, really, really difficult in practice because what makes something distinctive? How distinctive does it have to be? right? A great example is every time this arsonist commits an arson, he sets a bomb that uses certain things, and he, wires it in a certain way. And there's so many, like 7.5 twists, on this wire. And there's this kind of timer. And he uses it, it's a really distinctive way of making a bomb. And let's say we know he did bombs 1, 2, and 3. Maybe he's already been convicted for them. And his fingerprints were on something, and literally on bomb number 2. We're on bomb number 4, the case we've got. Sound good enough? Yeah, because it's really distinctive, and it's got to be this guy. Generally, for identity, the similarity between the prior or subsequent crimes and the current one has got to be really high. If you're offering it just for identity, the similarity has to be really, really close. Not as high in other situations. Now, you could imagine a scenario where you're offering evidence of another crime that isn't like this crime at all, right? Let's say a gun was stolen 4 days before a murder, and the gun that was stolen, and you've got the defendant on videotape stealing it and 3 witnesses, and you just nailed him, right? And you find the stolen gun in his possession after the murder. Evidence that he stole the gun, that crime, is really helpful in proving that's the dude that did the murder, even though nobody saw him do it and there isn't physical evidence. Why? Well, we saw him stealing the gun 4 days before. He's got possession of the stolen gun immediately after when the police arrest him. Pretty powerful evidence that that whoever had that gun before and after is the guy that did the murder with that gun, right? So even though it's not the same kind of crime at all, it's another crime, but it's really helpful to show identity because of just the relationship between the 2 crimes. So when you're talking about identity, sometimes it's not even close. It's a whole different crime, but because it's uniquely related to the crime at issue, that other crime can be really helpful. Like, when did he steal the gun and that kind of thing. If it's the same crime and it's just done in the same or similar way, it's got to be really similar to prove identity. Motive. Okay. Another crime, and this is the flip from identity, right? Another crime, usually one different from the one that's charged, is admissible if motive is disputed, the other crime was committed close in time, the state can show the defendant committed it, and the other crime establishes a unique motive beyond just everybody who commits the crime. If the motive is he stole money because people like money, well, sorry, that's not much of a help. If the motive is he stole money to pay the tuition for his kids, and that maybe that's more helpful. Anyway, we've got an example here. Defendant's charged with the murder of Adam. State proves he was previously charged with extorting money from Adam's market. Adam was the main witness against him, and the main witness against him disappears. Yeah, that might really show a motive. And how else are you going to show the motive without showing the other crime, right? The whole point of killing the witness is that you're charged with another crime. So you'd have to sort of show, there was this other crime, he's charged with it. By the way, this guy is the chief witness. Contrast that with defendant's charged with robbing Barbara. State offers evidence that the defendant's a cocaine addict. And the motive to rob Barbara was to get money for coke. It's not unique. Everybody who commits robbery wants property or money, right? That's why they do it. So the fact that he had a need for money is not particularly helpful in showing that he had a motive to commit this crime, because whoever committed it probably had a need for money. All right, intent, absent of mistake, or lack of accidents. And this goes to, did you have the legally required mental state? The defendant denies some aspect of the mens rea by claiming he didn't intend harm, it was a mistake, or it was an accident. The other crimes were committed reasonably close in time. The state can show the defendant committed the other crimes. And you'll notice that this reasonably close in time, and the state can show that you did the crime, is pretty much everywhere, right? Because if it wasn't reasonably close in time, or the state couldn't show that you did the other crime, then what the heck are we introducing the other crime for? So those two are everywhere. The state can show the defendant had the intent when the other crime was committed. For example, the defendant is charged with manslaughter for shooting a hunter while hunting. He claims it was an accident. The state can prove on prior hunting trips he intentionally fired his gun toward fellow hunters to keep him away from his favorite spot. Well, guess what? Maybe it wasn't an accident this time either. Okay. Knowledge. And contrast knowledge with intent, absence of mistake, or lack of accident. Intent, absence of mistake, or lack of accident, is we're talking about an element of the crime, right? Did you intend to do the wrongful act, or did you have the wrongful mental state that was required for the crime? In contrast, knowledge is not usually a commonly disputed fact, but if the crime is, say, drug possession, this is where this comes up a lot, is I didn't know that white powder was cocaine or methamphetamine or whatever the hell else. Really? Well, isn't it true that, you were in possession of methamphetamine on this occasion, you happen to be in possession of it in baggies, in small amounts, just like on this occasion, on 6 other occasions. And 3 of those times you admitted that you knew it was meth. So that tends to show what? This time you knew it was meth, okay? That's usually where it comes up for knowledge. Opportunity, preparation, and plan. Other crimes are theoretically admissible to prove opportunity, preparation, or plan if those issues are genuinely disputed, but it doesn't happen too often. The defendant claims to have no opportunity because he was out of town. Evidence he was in town, well, even if it's evidence that he was in town committing another crime, would be relevant, right? If the police can say that they saw you at such and such a place, and what did they see you doing? Some other crime. But you were there, well, that would show that you did have the opportunity. The fact that the defendant took steps to make preparation for a crime is circumstantial evidence he later committed it, even if the preparation involved criminal activity. Classic example, right? In order to get a cold car, in order to get a car that you're not going to be tied to commit a robbery or something, you steal a car. So that you use that car, which when the police see it, they go, oh, yeah, it's a stolen car. But it's not tied to you in any way, because it's not registered to you, you've never been seen with it before. And then you dump it and use your cold car. So the fact that you went and stole the car right before you committed the robbery using the stolen car could be used, if we could prove that it was you, your fingerprints are in the car or something like that, to show you had an opportunity or you prepared to commit the bank robbery because you stole the car right before you. And of course, we said the list wasn't exhaustive, so there's a common law exception. Some states, evidence of criminal acts committed at the same time is admissible to tell the rest of the story. So the defendant's charged with robbery might have fled in a car stolen in a different state. What was that? That was the same mid-green Skylark, whatever, that was parked outside the Sac-a-Says. Anybody see My Cousin Vinny? Okay. The officer who apprehended him may describe the stolen car, even though it's another crime, in order to complete the story of the robbery. And again, it's totally 403 stuff, and so often that's not going to be in there because there really isn't another. Why do you need to know that the car was stolen, right? Maybe it explains why the cops stopped you, but that's about it. Okay. All right. We've also got habits and business customs that are always followed. Okay, remember, we talked about this last week, right? What you usually do is not a habit. What you always do, your business's customary practice, this is what we always do. So one's for people, the other's for businesses, is not just a tendency, it's a habit, and it's admissible under 406. If an individual always does something a certain way, it's a habit. If an organization, corporation, or group of any kind, it's called a custom, and both are admissible. Habit and custom are generally proved by opinion testimony. The witness must have personal knowledge of the person or organization. The witness must have observed a large number of situations, and the person or organization must have always responded to the situation in a particular way. It's not enough that they usually act in a certain way. And at least with businesses, it's really helpful if you don't just have this is our practice, but you've actually got a policy. This is what we require our cashiers to always do X, Y, and Z. And of course, who can testify to this? Well, the person whose conduct is at issue, right? Who else is going to know I always run the light at the corner of Highway 111 and Deep Canyon or something, right? Okay, so that's our outline. And of course we got the 403, right? So let's go through some problems. Let's start with problem 557. Anybody want to do 557? How about the person who's looming over us from above? You want to do that one? Okay.
Okay, let me try this.
It's on page 180.
Okay, can you hear me?
We can.
Okay, so Henry Mancini, a homicide defendant, asserted self-defense. Offers evidence that he had heard that his alleged victim, Jesse Ventura, was an evil, cruel man. He also heard that Ventura, a former Navy SEAL, had been trained to kill and had the inclination to do so. Overwhelming evidence presented by the prosecution suggests that this view was wrong and that Ventura's reputation was profoundly undeserved. Perhaps it arose from societal stereotypes about the violent nature of large, bald men like Ventura. Nevertheless, Mancini argues over prosecution objection that the proffered evidence is still relevant non-character in the sense of non-propensity testimony and is therefore admissible. The judge admits the defendant's testimony. Is the judge ruling right?
Okay, so what the defendant says is, I heard all this stuff about the guy that I killed, and I believed it, and that's why that's why I engaged in self-defense. And the prosecution's like, that's all BS, right? It's totally not true. Do you admit what the defendant heard, even though it's not true, or probably not true? What do you think?
I would say that the judge's ruling to admit it would be right because he believed that this person that he killed, that's the way his character was.
Yeah. Okay, so it's not, let's start out by looking at a rule. Is it barred by 404B 1 or 8? Yeah, 404B 1. Evidence of a crime, wrong, or other act. Is this a crime, wrong, or other act? No, it's what was in his head. It's information that he was told about the victim.
Okay.
So it's probably not barred. No, it's not probably. It's just not barred by 404B1. Okay.
Okay.
So, is it relevant? Well, sure, the defendant's mental state, you know, if the defendant genuinely believed that he was getting attacked by a large bald man who's scary, yeah, yeah, right? Now, might the jury use this for the wrong reason?
They can, unless,
Remember last week we talked about who was the initial aggressor?
oh, that's right. We did.
Yeah, so maybe the jury uses this to think, well, that friggin' Renteria, he was the initial aggressor when there's really no other proof of that. But maybe we instruct the jury on that. And, you know, maybe some of this we don't admit, like the stuff about he's an evil, cruel man. But the trained to kill and had an inclination to do so? Yeah. Okay.
So does the judge instruct the jury on all this, on what not to?
What you can consider it for and what you can't consider it for.
Oh, okay.
Yeah, you're almost always going to get a limiting instruction about, we're introducing this evidence of an uncharged offense for this purpose. You may consider this for this purpose only, and you may not consider it at all if you don't think that the people who proved it, that it's more likely than not that it happened. Okay, what's the next question here? You're going to change your mind if there's an opinion witness testifying that he shared with Mancini his view that Renteria had a violent nature? Does that make a difference?
That was the, what was that, Rule 404, the person's character? Oh, no, that was,
This is what the defendant has in his head.
oh, okay. Okay, I see. All right.
So what's missing with that? Well, testifying that he shared with Mancini, okay? So the important thing there is, I told him, right? The opinion witness says, that was my opinion, and I told the defendant, this is what I thought about the victim. So the key is, what did the defendant know, right? Good grief. Getting way too many texts here. All right. Suppose we had a series of witnesses who told Mancini they had observed that violent nature. All right? Same thing?
I would say, yeah. From the one that also had the opinion of telling the Mancini about the guy's nature.
Yeah, so if you're considering it as propensity by the victim evidence, you know, who's the first aggressor, then yeah, that probably, you can't offer specific act evidence. But if you're looking at it only as what did the defendant know, well, sure, it's no problem because it's not even prior bad act stuff. It's just information that you got. See the difference? What we talked about last week versus what we talked about this week, right? So so if you want to keep it out, what are you going to argue? They're not offering it to show what he knew. They're offering it to show that the victim was the initial aggressor, and they can't do that, Your Honor. Okay?
Okay.
All right. And of course, there's always a 403 objection. Finally, you got a series of witnesses testifying to violent acts. That's not helpful at all unless somehow Mancini heard about it, and there's no indication that he heard about it, right?
Right.
Last there. Number 3.
Isn't 3 kind of like 2?
Yeah, except the point of the illustration with 3 is we don't have any indication that defendant heard about any of this.
Oh, okay. Okay. I see.
Right? Okay. And then they want to refer earlier in the book, and I didn't bring I didn't bring problem 553. Who wants to do 558 and tell us about 553, right? So anybody want to do 558?
So,
Great, go ahead.
assume that O.J. Minson in problem 553 is facing criminal homicide charges. The prosecution seeks to admit the evidence noted in part 2AC of that problem in its case in chief. The defense objects on the grounds that the evidence is inadmissible character propensity evidence.
So let's go back and look at 553 and see what 2AC was.
Okay.
And unfortunately, I didn't bring 553, so does somebody have 553?
Oh, sorry. It says 553C says, didn't Mr. Mimpson 3 years ago kick in his now ex-wife Mikkel's double French doors, breaking the glass and threatening to kill her?
Okay. So that's A through C?
Yeah. Oh, A through C? I'm sorry.
Yeah. Part
That was
2,
C.
A through C.
Oh, okay. Well, A is, did you know that 12 years ago, defendant Newsom was observed by police standing shirtless in his driveway? His then wife, Mikkel.
Yeah, we're trying to make it Nicole, yeah, right.
Nicole in bra and panties crying nearby while Mimpson held a baseball bat that he had just used to smash his car's windshield.
Okay, that's A.
Yeah.
What's B?
B is, have you heard that we heard that 7 years ago, Mimpson hit Nicole on her forehead, then repeatedly slapped her, bruising her face and resulting in his no contest plea to assault.
And C?
C is, didn't Mr. Simpson 3 years ago kick in his now ex-wife Nicole's double French doors, breaking the glass and threatening to kill her?
Okay, so those 3 things, 12 years ago, a little more recently, French doors, slapping her around. What was the first one? He smashed the car and he's shirtless and whatnot.
Yeah.
Okay, so now the prosecution wants to admit those 3 things in its case in chief.
Right.
The defense says, you're trying to do exactly what 404B1 says you can't. Evidence of a crime, wrong, or other act isn't visible to prove character to show that on a particular occasion the person acted in accordance with that character. So you're the prosecutor. What do you say to that?
I would say that it shows motive.
What's the motive?
He intends to someday kill her.
Pardon
He intends to someday kill her.
me?
Which is what-
Okay, well, now she's dead, right?
Right.
Do we have any indication that, and assume this is really like Nicole Simpson and Ron Goldman, any indication that it was an accident?
No.
No. Her head was almost completely cut off. He was pretty badly, whatever. So, okay, Madam Prosecutor, yeah. Not going to let you introduce it for intent because there's plenty of evidence of intent already. And even if it might show intent to kill, yeah, there's already plenty of 403, plenty of reason to exclude it under 403 because of prejudicial effect. Small probative value in light of all the other evidence we got. Another reason to put that in?
Well, did you just kind of refer to absence of the state then?
Same thing.
Same thing, yeah.
Motive?
Oh, yeah.
Why, how would this be used to show motive?
So over the years, is severe beatings and,
Guy's rather pissed at his ex-wife,
right, because he thinks she's dating this wrong.
or whatever,
Right.
right? When he gets upset with her, he really gets upset with her and does all sorts of crazy shit. So, okay, so maybe motive. Anybody have any other thoughts about motive? Okay, what about identity? Right? How are we gonna prove that it's frickin' OJ that did this and not, Colombian drug dealers going crazy?
Because of her past statement.
Yeah, well, or because of the fact that he's already victimized her 3 times, right? He smashed things, he smashed her car, smashed her face, smashed the doors on her house. Who the hell else might show up and kill her? Right? Everybody see why that might be a good thing to like help us identify. But look, it's not the same offense, right? It's not like, well, this is a really unusual way of committing a murder. It's not like he murdered other people using a left-handed thing with a curved blade, whatever, right? It's not a similar crime at all. None of it involves killing. Only one of it involves actually hitting a human being, right? But do we all agree that pretty helpful in like identifying the possible murderer here?
Yeah.
Yeah. So I think that sort of undermines our outline. Sorry, Pete. Where it talks about similar crime and all that kind of stuff. These crimes, in a sense, aren't similar at all. None of them are homicides. Only one involves touching a person, and yet it's pretty powerful motive evidence or identity evidence to show who did the murder. Yeah.
Under identity for section B, it says the other crimes were committed reasonably close. Oh, sorry, I read that wrong. Reasonably close in time. I thought it was reasonably close to the other offense. So I guess.
Yeah, no, that's what it means. So maybe the fact that one of them was 12 years ago. How about the fact that we've got like 3 of them though?
Yeah.
We've got like a string. Okay. So what about our fourth? Okay, we always have a 403 objection. So who wants to make the 403 objection to this? Anybody? Damn, this is like really prejudicial, right? Because it shows that it's going to take the presumption of innocence away from this guy, because it shows that he's committed other rather serious, smashing stuff up, smashing her up. So it's going to cause undue prejudice. And some of it, like you said, is really remote in time. It wasn't like it was last week or last month, 12 years ago, Your Honor. So how are we going to rule on that 403 objection? Or what's the prosecutor, what's your response on that 403 objection?
That the probative value is not substantially outweighed by the.
That's how you make a 403 objection. Okay, so the probative value is substantially outweighed by the prejudicial effect. That's how you make the objection. You're saying, it's not substantial. Hey, yeah,
Right, that's what it's.
okay, why not?
It's not substantially outweighed, it's not substantially outweighed by.
So why not? Well, what's the nature of that evidence compared to the nature of the evidence in this case? If you've heard that he killed 2 people and sliced one's head almost off, evidence that he smashed some French doors or a car, or even that he struck someone in the face, doesn't sound quite that bad, does it? Right?
Mm-hmm.
Here, if you compare those crimes to this crime, geez, is there really going to be is the jury going to be like, oh my God, I'm really shocked that he would smash up some French doors or a car or even his ex-wife's face. when we've already heard, you know, almost totally cutting her head off and killing the other dude in a rather horrible way. So maybe it doesn't have as much prejudicial effect when they've already heard a lot worse in this case. Another thing you might say, talking about the how long ago some of those offenses are, yeah, it shows a pattern over time. It's not like we're only introducing one thing from 12 years ago. There's 12 years ago, there's, you know, however close the other two are. To show kind of a pattern that helps, that maybe one incident wouldn't be helpful, but we can take all three of them together, it really does tend to show the identity, and it's not nearly so prejudicial. So what do we think? We're gonna let it in? It's freaking O.J. Simpson, of course we're gonna let it in. All right. And is there anything else that you might want to know about those other offenses to help the prosecutor here?
What do you mean the facts that, any other facts that are not?
Yeah, other facts about the other offenses.
Well, they're extremely violent, he's bashing them.
And I mean, is there anything else you want to know about them? Maybe some context for those other crimes, like you just heard he was dating some guy or something like that. Yeah. Or there was, you know, cheating on him. How do you cheat on your ex-spouse? I've never been able to figure that out. It's your ex-spouse. Anyway. Or maybe, you know, it's all about control. So, okay, so that's our OJ case. All right, we got some examples here, and then let's talk about problem 559. Who wants to do that? And by the way, the fact that this is in the motive section might give you some idea about what they're trying to get at here. I'll do it. Okay.
All right. Physician Dr. Stephen Kumar is charged with prescribing controlled substances not in the usual course of professional practice and not for a legitimate medical purpose. In litigating a motion in limine, the prosecution called 5 witnesses, each of whom was a woman who testified roughly as follows. When she asked Kumar to prescribe Quaaludes, he responded by asking her to perform, is it fellatio or fellatio?
Fellatio.
Fellatio.
Give him a blowjob.
Oh.
Oh, yes. Yeah, that's what that means.
After each,
I know, this gets to be there's a much more interesting problem all of a sudden, isn't it?
after each woman completed this act,
There you go.
Kumar wrote her the requested prescription. Should the court grant the prosecution's motion for a pretrial ruling that this testimony is admissible, why or why not?
Okay, we're gonna admit this? Okay, first of all, let's see what it is, right? Is this evidence of another crime?
No, it's testimony.
No, but it's
Oh, it's
arguably the other crime is forcing a woman to perform sex on
or
you.
another.
Or is it a
act.
crime? Maybe it's not a crime, maybe it's just a bad act.
It could be a wrong or an act.
Yeah, so it's another act. Does the fact that, you know, you ask your patients for a blowjob tend to indicate that you're more likely to prescribe medication when it's not medically justified? It's a bit of a stretch, isn't it? Right? So if we go back and look at our rule, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with that character. Okay, so these other incidents where he's asking women to perform oral sex on him, yeah, so are we trying to show that, well, what's he accused of this time? I guess the crime of not prescribing medications in the ordinary, you know, whatever.
Course of practice,
Yeah.
and not for legitimate.
Okay, so maybe this is, I mean, we don't know whether literally he's being charged with each of these five incidents he's prescribing medications not in the usual course of practice. if these are really actual specific incidents of improper prescriptions, guess what? That is the charge defense, right? So, maybe you say, no, it's just writing the prescription. It's not blowjob and writing the prescription. Although good luck with that argument. So it may be that this is the charge defense, right? We don't know. But if it is the charge defense, guess what? Of course it's coming in. It's evidence of the charge defense, not some other crime, right? But let's say it's not, and in this particular instance, this is another instance of writing scripts that weren't justified. Now what do we think? Because arguably this is if it's not a crime, it sure as hell is a wrong, right?
Yeah.
So is it being offered to show that in this particular occasion, the person acted in accordance with that character? It's hard to say that, the sleazeball who's exploiting his female patients, well, he's more likely to write prescriptions that weren't justified. So, yeah, probably not a 404B1 problem. Maybe. Okay, but what about why would the prosecution, what's the prosecution doing as a permitted use here? You're gonna offer it for another purpose.
For motive.
Okay, he's writing bad scripts because he likes to get sex from his patients. Yeah, that's pretty good one.
But then there's gonna be 403 objections.
Yeah,
all day.
How about knowledge that he knows this isn't for he knows he's not writing proper scripts, right? Because he's going to say, oh no, it was justified by the patient's medical condition and all that. He knows he's not doing it for that because he's really doing it for sex, right? So maybe it's motive, intent, what he really intends to do, plan, knowledge, I don't know. We're some sort of amalgamation of all those things.
Doesn't the intent go to the elements of the crime though?
Yeah. Yeah, and here he's going to say, look, my intent was to write scripts in the usual course of professional practice, and for a legitimate medical purpose. Well, this shows that's not what you intended at all, right? Anybody have any thoughts about this that we haven't talked about? If the issue is why did he write them, then not for a legitimate purpose. Well, this is pretty powerful evidence that on other occasions, again, maybe these are the occasions, but on other occasions, if they aren't, that he wrote it for an improper purpose, right? And it does tend to suggest a pattern too. So that if you do it on those 5 occasions, you probably do it here. All right? Okay, next. Man, that was a lot more fun than OJ. Okay, let's do 561. Who's got that one?
That's good.
Okay.
Let's see, Montana Redwood is on trial for homicide. In cross-examining prosecution witnesses, defense counsel revealed the defense theory that Redwood killed Molly Ringwater because Ringwater was attacking Redwood's wife. The prosecutor offered evidence that Redwood had had sexual relations with at least 20 other women during the year before the killing. Admissible? Why or why not? Should the ruling change if the prosecution also offers evidence that Ringwater had told Redwood's wife of Redwood's infidelity in a conversation that took place shortly before Ringwater's demise?
Ooh, okay. So let's talk about the first evidence, right?
Mhm.
Prosecutor says, well, here's the theory, right?
Mhm.
That the defense says, hey, Redwood kills Molly Ringwater because Ringwater was attacking Redwood's wife. Okay. Here we go. Montana Redwood, prosecuting the defense counsel, that Montana Redwood killed Molly Ringwater because Rainwater was attacking Redwood's wife. So Molly is going after Redwood's wife. And the prosecutor says, oh yeah? What about the fact that Redwood had sex with like 20 other women in the year before the killing? Why would that be admissible? Or not?
So, what's your-
Well, it sounds like, you know, he's like defending his wife, right?
yeah, it sounds
That's
like
what the
he's
defense is
defending-
trying to suggest.
He's defending.
Like he gives a damn about his wife if he's sleeping with 20 different women.
So it would,
What do you think?
in this case, it would be, you would argue that it should be admissible maybe to argue motive, that why would,
It sort of undercuts the
yeah, to
defense's case.
undercut his
Yeah,
defense.
because it sounds like, hey, I'm defending my, you know, I'm trying to protect my wife here. And the prosecution's like, yeah, like you give a damn about your wife. Is that why it would be admissible? Okay, it's a crime, wrong, or other act. Okay, but it's not really being offered to show that on a particular occasion he acted in accordance with the character. So we really don't have a 404B1 problem, right? Because it's not like, well, he killed this person because he killed somebody else, and he killed somebody else. It's just, you know, what does sleeping around have to do with killing somebody? Okay, well, what about, how about if we found out that the dead woman had told Redwood's wife of his infidelity just before he allegedly killed her?
Well, then you would argue motive.
Motive! What's the motive?
He was trying to.
Revenge.
Yeah.
Yeah, I'm gonna make sure. Bitch told my wife about the fact I was sleeping around on her. We're gonna take care of her, right? That's pretty powerful motive, actually, especially because of the timing. So, okay. Let's see. Let's see. Yeah, okay, so I suppose without the revenge thing, you've got a 403 objection. If you're gonna make it, what are you gonna say? You're the defense. Hey.
You would say that.
Why are you letting in all this evidence of adultery? Right? Why?
I'm saying why, the defense or the prosecution?
Yeah, the defense.
Well,
You're trying to keep it out.
you would say that would confuse the jury, confuse the issue.
How about a undue prejudice? Even in this day and age, jurors are likely to go, what the, he slept with 20 different women? I mean, that's pretty bad, right? I mean, I get that, you know, not every marriage is perfect, but come on. 20 different women, that's probably gonna get an emotional reaction from a lot of jurors. Okay, you know, and really how probative is it?
Well,
Well, it sort of undercuts he's trying to protect his wife thing. It does, but I mean, how do you
But it's
balance
not
that
really-
versus the, yeah. But if you introduce that motive, that's,
that changes it.
then the probative value goes up a lot, doesn't it? Okay. All right, let's do some stuff under opportunity. 564, he wants to do 564.
Okay.
All right.
Latif Lima was arrested for the bombing of a federal office building after police viewed a videotape that showed Lima hurriedly leaving the building moments before the explosion. Forensic analysis revealed that the explosion was caused by an experimental explosive device, one that was part of a governmental research project contracted to a private entity. The state offers evidence that 3 weeks before the explosion, Lima burglarized a warehouse of Regio Tech Corporation, the private contractor working on the experimental explosive device. Admissible what? Admissible or not? What?
Okay, so
So
what are we offering? Evidence of another crime.
Another crime, yes.
The other crime is
Burglarizing Regitech.
burglarizing this other company
Was
that's working on this kind of unique experimental explosive device. That would seem to be pretty good. What, would you admit that?
it's highly probative. I mean, well,
Okay, how is it probative? What does it help show?
well, I guess we can talk about opportunity, that
Oh, we can talk about opportunity. How about identity?
identity. I mean, who else could have done it other things? Her who burglarized that same
I mean,
store.
whether you call it opportunity or identity, it's like somebody used a bomb, this experimental bomb, right? If you happen to have burglarized the place 3 weeks before and you had access to it, that's some pretty good evidence that it might have been you. And you can call that opportunity or identity. But I think it's pretty powerful evidence. Anybody disagree? Anybody think you're gonna not admit it? Maybe a 403 objection? Anybody think 403 objection?
I mean,
Why is the 403 objection not all that great here? Well, one, burglary, stealing a bomb isn't nearly as bad as
well,
arguably burglary, planting a bomb to blow someplace up. You know, actually using the bomb is a hell of a lot worse than just stealing it. So and we're already hearing that the guy like entered someplace with the intent to blow it up. So he's already, you know, being accused of a burglary. So the undue prejudice is like, yeah, well, they're going to hear a lot worse, right? What do we think? Anybody think they'd sustain a 403 objection here? What do you think? What do you think, San Bernardino?
I think it's kind of weak, but I would probably use unfair prejudice.
Okay, what's the unfair prejudice?
Well, because that he was working on experiment. This other place was working. They burglarized this other place, and that has explosive device, but it's kind of weak. But maybe I could argue it. You know, unfair prejudice on it. It's not.
They tell us that, hey, we checked it out, and the explosion at the federal office building was caused by an experimental device, and it was one part of a government research project that was being worked on by Regotech. Still unfair? Right. It might depend on just how good the evidence is how powerful this evidence is that he was caught doing that other burglary, right?
Oh, okay.
If it's kind of lame evidence that he was caught doing the other burglary, then you might say, well, geez.
Could it be if he was successful in burglarizing the other?
Yeah.
Then it was way stronger.
Clearly, that's what the prosecution wants you to believe, right? Is absolutely, this is the guy, we got big evidence that this was the guy that committed that other burglary and stole the experimental device. And aha, the experimental device shows up here. So, ain't just anybody has this experimental device. And we know that this dude did, because we saw him burglarizing. Okay, yeah, I think probably because of the uniqueness of this, with the type of bomb and stuff, it's that you're gonna have a hard time with a 403 just because the probative value is so high. All right. What do we, let's do. All right, let's talk about identity, because like I said, the standard's usually higher for identity. Okay, so how about 567? Anybody want to do that? Who hasn't done it? Is everybody? Yeah, okay, who wants to do number 2? Anybody?
I'll do it.
Okay.
All right, on March 31st of last year, 2 local detectives saw Willy Wonka accepting money from passerby, then immediately handing each of them a brown paper bag that he plucked from the wheel well of a pickup truck. After each transaction, Wonka crossed the street and handed something to Dr. Morris Doolittle, who stood in front of his store, Doolittle's Video. As it turned out, Doolittle owned the pickup truck. On that date, one of the detectives purchased what appeared to be cocaine and marijuana from Wonka via this procedure. When the detectives later legally searched the pickup truck and Doolittle's video, they found illegal lottery betting slips in both locations. However, Doolittle was not then charged with illegal bookmaking. 5 months later, officers executed a search warrant at 555 Co-op City Avenue based on an informant's report of drug dealing at that address. They found crack cocaine, a triple beam scale, a digital scale, small bags of the kind used to package cocaine, and $12,000 cash in a suitcase, as well as illegal lottery numbers and lists of bets written on them. At Doolittle's trial for possessing the cocaine found at 555 Co-op City Avenue, the prosecution seeks to offer evidence of 1, the Willy Wonka investigation of last year and the betting slips uncovered during that investigation. 2, Doolittle's conviction 5 years ago for running an illegal lottery. And 3, the list of bets found during the Co-op City Avenue search. The prosecution argued that these items are admissible to prove Doolittle's identity as the owner of the Co-op City apartment. How should the trial judge rule and why?
Yeah, what do you think? We're gonna prove that it's his place with all this important evidence of drug dealing because we've got bookmaking stuff.
All right, so for the Willy Wonka investigation of last year and the betting slips uncovered, I'd say that could be you could really do it for motive, for intent, for knowledge.
Yeah, but basically it's showing it's the same guy. Right?
Right.
That's why we're offering it. We're offering it to show he had dominion and control over that premises at 555 Co-op City Avenue. So we've got betting slips and betting activity, even a conviction, right? Earlier. I think. Yeah, Doolittle's conviction 5 years ago for running an illegal lottery. So is that so distinctive that we're going to say, oh yeah, it's got to be him?
For the first one? Yeah.
Well, any of the 3 things.
Well, the conviction closely relates
To what?
to the case at bar.
Yeah, but is it so unusual to do bookmaking and drug dealing that we're like, well, damn, this has got to be him? Because it's got bookmaking and drug dealing.
Right.
What do you think?
No.
Probably not, because if you're going to do one form of illegal activity, you might be likely to do another one. And there's nothing really unique about, at least they haven't told us anything really unique about the bookmaking that it's like so probative that you'd say, well, this bookmaking stuff, it's got to be Doolittle's, right? And there isn't anything that in the co-op that's there are drugs, but there are also drugs. But there's nothing so unique about the drugs and anything that you go, oh, well, that's got to be tied to that, right? So, I don't know. This seems kind of weak to me, just because probably a lot of guys run drugs and do bookmaking
At the same time, yeah.
Yeah. So for identity, it's got to be better than this, I think. And the conviction, 5 years ago, he's convicted for bookmaking. Okay, how does that relate to what's going on in the co-op address? Really need something far more distinctive, I think, than what we've got here. Okay,
I think the only thing is
yeah.
that you could even potentially really argue is the investigation from the year prior, because it's all about his drug dealing, pretty much, you know,
Yeah,
and this is for cocaine possession.
right, so but what's so unique about the drug dealing the year before, they could say, well, this has got to be that same dude running this drug deal this year?
Nothing
Yeah,
for.
I mean, there's nothing really, it's not like they had some unusual, unique way of dealing the drugs. You know, that you could get the drugs and go, oh, well, the drugs here at Co-op City Avenue, man, that's packaged exactly the same way and the same brand of, you know, what doesn't sound like it's,
Yeah.
it's a drug dealer, right?
Who's the guy that played Willy Wonka in the old movie? Was it Gene?
Oh, Gene Wilder.
All I can think of after reading this is just him coked out.
Yeah, absolutely. I can see it. I can see it. Okay, let's do another identity one. Drug courier profile, that's always fun. Anybody want to do that? Number 68. By the way, the Supreme Court has at least once and probably a bunch of times published the old drug courier profile. So it's like, this is what they're looking for. If you do these things, buy a one-way ticket, pay in cash, wear dark glasses all the same time, look really nervous, don't check any bags, you know, all this kind of thing, you're probably a drug courier. And so if you actually are a drug courier, what do you know not to do? Well, you buy a round trip ticket, throw half of it away. You pay cash, well, maybe not. Maybe you use the stolen credit card or something. Whatever. Anyway, just don't do all these things that the Supreme Court says that's the drug courier profile. Check a bag, right? What do you put in it? A bunch of dirty laundry. Who the hell cares? You've checked your bag. So anyway, it's always amused me that the Supreme Court, they're going to tell you what not to do to get arrested as a drug courier. Just don't do this. Anyway, and some of it you can't help, but some of it is like, well, okay, I think I can learn from that. All right, anyway, drug courier profile. Who wants to do it? All right.
Let's see, Jason Melwood is on trial for possession of cocaine with intent to distribute it. The prosecution called the police expert on drug courier profiles to testify that Melwood fit most of the elements of the following drug courier profile. Flight arrival from or departure to an identified source city such as Miami. Arrival carrying little or no baggage or large quantities of empty suitcases.
Aha! Sounds like what I said. Okay.
Unusual itineraries such as rapid turnaround time for a lengthy airplane trip.
Yeah.
Use of an alias.
Yeah. Who gets to do that anymore? Right? Now you got to show government issued photo ID. Okay, that didn't work. Anyway.
Carrying unusually large amounts of currency, many thousands of dollars, usually on the person in briefcases or in bags.
Yeah.
Purchasing airline tickets with a large amount of currency in small denominations.
That's getting fairly specific there.
Unusual nervousness beyond that ordinary exhibited by airplane passengers. The almost exclusive use of public transportation, particularly taxicabs and departing from the airport.
Yeah, your drug couriers don't show up on the bus. Okay.
Making a telephone call immediately after deplaning.
Yeah, okay. Yeah. Like now?
No.
Nah, no. Now this one, everybody makes a freaking phone call after they get off the plane. And sends like 12 texts and
I think that's when they were like pay phones. That's
yeah, exactly. Yeah. This was before everybody had a phone in their pocket. Yeah. Okay. Anyway, just assume this is what the profile is. Okay.
Leaving a false or fictitious callback telephone number with the airline. Excessively frequent travel to source or destination cities. Melwood was observed engaging in the same profile-like behavior on 5 separate occasions over the course of the 3 months preceding his arrest. Only on the 5th occasion did officers arrest him as he picked up a bag from the luggage carousel. A bag they later found to have cocaine stored in hidden pockets. The state's proffer includes these officers' testimony. Melwood's defense is that he simply picked up the wrong baggage at the luggage pickup area since the bag containing the cocaine had no tags identifying its owner. Defense counsel objects to the profile testimony as relying on a prohibited propensity evidence. The prosecutor responds that the evidence is offered to prove both modus operandi and that Melwood did not merely possess the cocaine for his own use. Rather, he was a drug courier, a person who acted with the intention of aiding in the distribution and sale of cocaine to ultimate buyers.
So what's at issue here? When he picked up that suitcase, was it a mistake? Because that's what he says. Or was that his suitcase? And were those his drugs? So now what do you think about all this drug courier stuff?
Well, there was a lot of them that isn't sufficient to make it so specific as to be unusual. But they say it was 5 times purchasing airline tickets with a large amount of currency in small denominations. I'm guessing we have to assume that this is before they had cell phones, with the
Yeah,
telephone call. So leaving false telephone number and not just once, but 5 separate occasions. But I'm not sure if that still would be sufficient to say, sufficient to, I guess.
Yeah, some of the stuff we really don't know.
Specific.
Like,
Yeah.
what percentage of drug dealers versus what percentage of the non-drug dealing public do each of these things, right? Or all of them together. Maybe you run some sort of statistical analysis that you say, yeah, a lot of the public does this one and some other of the public does this one, but when you put all the probabilities together, alert, it's practically all drug dealers and how many things does this guy get?
Because you could take each one individually and find different reasons why.
Yeah, so it's gotta be, you gotta hit like on a whole bunch of things, right? And if he doesn't bring up the mistake thing, then it's really hard to introduce this.
Mm-hmm.
If he does bring up the mistake thing, maybe you've got a better argument for it. But the fact that so much of this is just like, well, lots of people do that, or that's not so unique or whatever. It's not all that unique a signature,
Mm-hmm.
It's not that 3 twists of the wire on the particular type of bomb, is it?
No.
So I don't know. Yeah, but what makes it potentially admissible though is that, hey, when my suitcase, right? Which is why you get the video from the departure airport and you see him like checking the suitcase. Anyway, that's getting into too much of the real world. All right, let's look at problem 569. Mysterious crib deck. And just for some context, we're looking at intent or knowledge here.
Okay, so Molly Faluti's 3-month-old baby recently died in what she claimed was an instance of crib death. Crib death is a sudden and unexpected cessation of breathing or an inability to take in sufficient oxygen. In fact, babies drown in a sea of air. This is Faluti's 4th child to die of apparent crib death, and she has been charged with homicide.
So she is either like the most goddamn unlucky parent on the face of the earth, or she's doing something, right? So what do you think? You want to introduce the other? You're going to let the prosecution introduce those other crib deaths? You know that's going to substantially increase the likelihood that she gets convicted because jurors are going to be like, hey, once it's an accident, 2, probably not an accident, 3, 4, no, not an accident, right?
So,
and at some point you run out of bad luck, right?
there's this concept that's described about like the doctrine of objective chances. It's too many instances can't be an accident or mistaken after a certain number of times. Because 4 is too many times it's happened.
So what do you think?
I think they admit it.
You'd admit it?
Yeah.
That's like really powerful though, right? I mean, everybody recognizes you're convicting her.
Yeah.
Right? If you introduce that other stuff, she is F.
Yeah.
I mean, she is so going down.
403.
Yeah. Right? So is there anything you'd like to know about this that they didn't tell us?
What were the circumstances?
Yeah, how
Other-
similar is it?
Yeah.
Right? Is it happening exactly the same way? Did she give the same explanation to the police every time? Yeah. But this is a total, is it really all that unique? Right? Well, yeah, 4 times,
Yeah.
that's pretty unique. But any one of these, that can happen to a whole bunch of parents. But it's that 4, right? And the jury's never gonna use this for the proper purpose. If you're telling them the purpose is knowledge, or whatever, the jury's not doing that. The jury's like 4 times, she's doing something. We don't know what it is, but she's doing it. So, okay. How about, number 7, 570? Anybody want to do that? Okay.
Quentin Kress is charged with malicious assault of a fellow prisoner. Malicious assault in this jurisdiction is defined as assault done with malice, which is a purpose to cause intense physical pain or psychological humiliation. The prosecutor seeks to offer evidence of Kress's subsequent acts of cruelty toward the same victim. Will the prosecutor succeed in admitting this evidence? Why or why not? Or additional information that he would have in this decision?
Okay, so first of all, does it matter that the acts that the prosecutor wants to introduce are subsequent? What did we say? Just because we usually call it prior acts, doesn't mean they have to be prior. If they're showing intent, it can be afterwards too. Remember my dead baby case, right? The prosecution got to use evidence of the first murder and evidence of the 3rd kid's abuse to show what happened with kid number 2. It can happen just because we call it prior acts doesn't mean it has to be prior acts. It's other acts, all right? Remember the rule doesn't say prior, it says evidence of a crime, wrong, or other act. We always call it prior bad acts because often it is, but it can be subsequent too. Okay, so the fact that it's subsequent, no problem. All right. Prosecutor, you're going to get in the subsequent acts of cruelty. What do you think?
Motive intent.
Pardon me?
Identity, it's the same guy.
Okay, but what about if we're just worrying about intent? Suppose identity isn't an issue. The whole thing is he's like, I was defending myself. Prison's a dangerous effing place, right? I was defending myself. So you're always defending yourself against the same guy? Well, yeah, same guy's from that.
Also in prison.
So if the defense just is, hey, I was defending myself, then evidence of those other incidents probably going to be real useful to show what your intent really was. Was it self-defense or was it cruelty or malicious? Okay. Now suppose it was identity, right? Then what do we have to find out about those other incidents? How similar they are, how unique the method was, if it's always like doing a particular thing that not anybody else does, yeah, it's helpful. If it's not, well, then it's not, and it's not real helpful. How about our confused bookkeeper? Anybody want to do that one? Number 71? It's short, don't worry about it.
I can do that one.
Okay.
So Dalton Rumbo admits that he made a serious error in bookkeeping, but told his employer that this was an unknowingly mistake. An auditor uncovers 10 similar such mistakes by Rumbo during the past year. Could evidence of these 10 earlier mistakes by admitting at Rumbo's embezzlement trial based on his most recent bookkeeping error?
Okay, so he says, oop, I fucked up. But notice he's now on trial for embezzlement, so this is back a criminal case. At the start, it sounds like, well, maybe it's a civil thing or whatever, but no, and his trial for embezzlement. So he's getting tried for stealing stuff. We're gonna introduce those other 10 mistakes.
I think the prosecution would try to bring these, yeah,
So you're gonna admit them?
to show his intent.
This wasn't any just like innocent screw up, right?
Right.
I mean, how many times do you innocently screw up in the same way? Right? So what we to top it off, what we'd really like to know is how unusual are these mistakes? Right?
Right,
Is
right.
he making the same mistake all the time? And it just happens to be one that really benefits him or whatever? Or is it just, or is he making different kinds of mistakes? And they don't really tell us, right?
But he apologized.
They say they're similar, right? Yeah, he did apologize. But similar, okay, how similar, right? Can anybody see a serious 403 objection here? Yeah, because if you hear that the guy has stolen from his employer 10 times, you're going to convict him of this one, right? Because you heard he did it a bunch of times. So the jury's going to may have a hard time considering for just the it's not a mistake purpose, right? On the other hand, man, is that some powerful evidence that it's not just a mistake. So that 403 thing, it's pretty probative, really probative, but it also may be pretty prejudicial, right? Okay, let's do a couple more. Why don't we we're running out of stuff here. Why don't we go over to the comic book thief? That sounds pretty good. 575. And this is under, it's a common plan. Okay? Who wants to do this? Anybody, come on. Who hasn't done two? Has everybody done two? Okay, who wants to be like a star and do the third one? I promise you, it won't be painful. It's about comic books. Come on. It's gotta be fun.
Morris Morrison is charged with burglarizing Mary Johnson's home and stealing her valuable collection of rare Marvel comic books. The only evidence against Morrison is that the stolen comic book collection was found in his apartment
Yeah,
and it was
correct.
searched pursuant to a valid search warrant.
Yeah. Mm-hmm. Okay.
Morrison's counsel plans to argue that this argument supports a conviction for the lesser offense of pursuing
Alright.
stolen property but does not establish burglary. The prosecutor offers evidence via eyewitnesses that Morrison engaged in the following prior uncharged acts. 1 year ago, he used his building superintendent's pass key to enter a neighbor's home and steal a collection of DC comic books. 2,
Okay.
he used a hatchet 5 years ago to break into a local comic book store where he stole the entire collection. And 3, 2 years ago, he bribed a salesperson in a comic book store to sell him rare comic books at below their fair market value. The defense objects. Should the objection be sustained? Why or why not? So I mean, you could use any of these to show, because there's 3 separate occasions with very similar like crimes, you could show that it's habit.
Yeah. He always, every time he hears about the existence of comic books, he steals them. No.
No.
What about the fact that you got 3 separate incidents, right?
So, yeah.
I mean, none of them by themselves is all that helpful, right?
Right.
Because, you know, they're little probative value, big prejudicial effect. And they're not all the same, right? One's a hatchet, one's a passkey, one's bribing somebody. Man, on the other hand, what is it with the effing comic books, right? Sort of suggests, even though it's not the same plan every time, he's figuring out ways to get comic books, right?
So then which one would that fall under? Which 404 would be? Which category would that fall under then?
It sounds like he's got a plan to get comic books, right? Any way he can. Common purpose, I guess, maybe, huh? Now, suppose it was a particular, you know, like they ask us about, suppose it was Spider-Man comic books in all 3. Wow, that's really suggesting some motive this time, right?
Yeah.
Right, like he really wants to get the Spider-Man comic books and he's gonna do whatever he has to. But they're still spread out as the time, right? Okay, now collapse them and they're all within 2 weeks.
Well, they're within a reasonable
Yeah,
time.
that's getting within a reasonable amount of time. He's really out to get those Spider. He's freaking freaked out about the Spider-Man books, and he's doing anything he can to get it. So in that scenario, that's probably almost certainly admissible. But notice that on the one hand, it's like any one of these has a significant. It isn't all that probative, but it has a significant prejudicial effect. But when you lump them all together, man, the probative value really goes up a lot, right? So ironically, even though it's and the prejudicial effect of any one of them goes down, right? Yeah, second one, third one, who cares, right? You're already hearing about a couple other steps. So the sort of prejudicial effect of any one of them kind of goes down, but the probative effect of all of them really goes up.
And the more narrow you get.
And exactly, the more narrow in time and the more specific it is to what he's stealing, higher probative effect, right? So this is all about a 403 objection and how much you weigh that probative effect. And when you're arguing common plan, the more common it is, man, the better it is. Okay. Do we want to do any more of these? Are we having just too much fun?
I like 403 objections.
Oh yeah, well, get used to it because there's a lot of them. There's a lot of them. But remember, 403, it's all about context, right? And if you're making it, you got to be creative about why it's, you know, hit multiple things. It doesn't just confuse the jury; it's also unfair prejudice. And if you're trying to get it in, it's give me a limiting instruction. Hey, it's not nearly as bad as what they're already going to hear. You know, that kind of thing, right? And it's really, really, really powerful. And ironically, sometimes like this, it gets way, way, way more powerful when you have more crimes. So, anyway, all right. Okay, so no one's back next week, goddammit. I'm tired of doing this by myself. And actually, I already told him the first week of November I'm not going to be here because I got to go to San Francisco, I think, for some training in death penalty cases. Not that I really want one, but 2 of our well-experienced, well-qualified death penalty judges just retired. So somebody's got to know how to do them, or at least be qualified. So I'm going to go to class. So I'm going to be gone the first week in November, and he'll be on his own, and I'll get even with him another week too, I'm sure. Okay, so everybody know what we're doing next week? It was on the syllabus, which I did not bring with me, but I think we're moving on to chapter 6.
Is next week the review?
I can't remember. It could be.
It's a review.
You will find it. Okay. All right. So you will. Anyway, we'll see you next week. No one's all over sending an email. That's his job. Everybody sign in here.
Yes.
Yeah.
And we will put Clara, you are online, right? Okay. Online. All right, Nolan, dude, you got it next week. Thanks, everybody. This stuff is kind of fun, right? I love doing the problems because they're it's way easier than just trying to read the rules.
Yeah.
Law school books. If you look it up too, if you look up places on Quibi and stuff, for property or whatever, they're all CTEs. We pretty much all use the same books. And it's funny that, you have editors, literally these books that don't catch this shit. In the however many problems we did, there were like 3 problems that had specific typos with like tense issues. You know, where they would put past tense or present tense and just fuck it up.